So the next question I have, and I'm interested to see how chat answers this one because it's going a little bit more complex into the nature of injury law. So we asked ChatGPT, how do you advise clients on whether to accept a settlement offer or go to trial? And its answer was, as a personal injury lawyer, I evaluate the strengths and weaknesses of the client's case and assess the likelihood of success at trial, as well as the potential risks and benefits of accepting a settlement offer. I provide the client with all the necessary information to make an informed decision that is in their best interest. If the settlement offer is fair and reasonable, I would advise the client to accept it. But if it is inadequate, I would recommend going to trial. Ultimately, the decision is up to the client. How do you feel about that?
I will give that I'll give it a B.
Okay.
Because here's what I'd add to that is that you are accepting the risks and benefits of a settlement offer. You need to decide whether a bird in the hand is worth two in the bush. Mm-hmm. Sometimes could you get more at trial? Sure. But are there attendant risks where you could get less too? So you have to balance all those things. But what ChatGPT is missing on this one is, what if the settlement offer is going to go up before you get to trial still? I do this all the time. I have these conversations, real conversations with clients like, hey, they've offered you $200,000 now. Mm-hmm. I'm not saying we go to trial, but here's what I'm going to do. I'm going to go hire this expert. We're going to disclose our expert. They're going to they're going to see what a great expert they are. And then I think their offer is going to go up to $300,000 or $350,000. Or we're going to go ahead and take the video depositions of the doctors so that they know we're really going to trial. And I do this all the time, Dave, and you know how much litigation and trial work we do, but other folks may not. But I'm taking video depositions all the time about getting ready to go to trial, and then these cases settle. The surest way to have a trial is, this is also not in there. The surest way to have a trial is not be prepared. The way to not have a trial is we do all the work. We're filing the motion. We literally had a case scheduled for Monday. Their offer was $40,000 for years. They offered it. We settled this case Friday for $250,000, the policy limit, because we would not accept anything else. Mm-hmm. And we were filing, I have a saying, a motion a day keeps the trial a day. So for about can I give you a secret?
Sure.
For about the 30 days before a trial, I'm giving the other lawyer something every day, just one thing. This day I'll give them the jury instructions. Just do a motion to eliminate. This is my brief on this is what this is what the voir dire is going to be like. Here's my supplemental medical records. Here's my business record filing. I have all these things I do, and they just get one a day, and they're like, holy shit, I'm not going to go to trial, and this guy is going to whoop me.
Yeah.
And so what they're missing in this answer is it's more nuanced than this. It is my job to maximize the recovery, but also put in the right work. And you got to know, ChatGPT won't know this, but you got to know the pressure points to push on the other side to have them say uncle and pay you. So policy limit demands, taking doctors' depositions, saying, I tell them all the time, listen, here's the deal. We're 2 months away from trial. I'm about to go spend $10,000 to take 2 to 3 doctors' depositions. The doctor's fee, the court reporter, the videographer. We take all these by video. Then we're going to cut our videos and we're going to present them. Then we're going to play them at trial. So by this time next week, the price of poker just went up $10,000. You better settle the case now. And lawyers who know what they're doing on the other side, they know that, and they're like, oh shit, he's getting ready. So yeah, we need to do that. So there's a lot of gamesmanship. The art, I negotiate for a living, and the art and what buttons to push as you're heading towards trial maximizes the settlement for the client.
So we talked a little bit about where as soon as you mention the word lawyer, things change with the insurance company. What about when you start mentioning the word trial?
Great point. And I tell you, I do this all the time with the lawyers that work for me. They won't give me this deposition. They won't do this. They won't offer anything more than after we file suit. Blah, 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 blah. My answer is set it for trial. We do motions to set cases for trial all the time. We're done talking to you, blah, blah, blah. Because the defendant and the insurance company know, the defense lawyer and the insurance company know, ultimately the only power that an injured person has is trial. It's not hiring a lawyer. It's not filing a claim. It's not filing a lawsuit. It's trial. Ultimately, they don't have to pay until there's a judgment. And we already talked in another question about the insurance company's duties to the insured. So they have duties to the persons being sued, and they got to act in good faith. And they can't sit and lowball offers all day and make this poor guy go to trial when he was just looking at his phone because his wife was texting him and he rear-ended someone. Why should he go to trial and risk his house and an excess verdict over his insurance limits? That's bogus. Insurance companies cannot treat people like that. They do it all the time. They force people to go to trial all the time when they could have settled these cases.
Well, and you've talked about, too, just leveling the playing field, because when you take we've talked about, the average person versus multi-billion-dollar insurance company.
Oh, yeah.
Lawyers and people that are trained specifically, because I won't go into the foil hat conspiracies, but I would assume that you had talked about these adjusters, that they're specifically trained to ask certain things a certain way to try to trick people into saying these things. So do you mind talking about that just a little bit, too?
Insurance is, these insurance companies, their profit margins are huge. I did an article on this about 2 or 3 months ago on the profit margins, the billions and billions the insurance companies make over excess premiums in excess of the claims paid. Can I add one other thing about when it's too late to hire a lawyer that ChatGPT missed?
Yes.
We asked a minute ago about when's it too late to hire a lawyer. Here's the other time it's too late to hire a lawyer is if you've signed a settlement agreement, if you settled your case. So we were talking about insurance adjusters trying to get you to settle your case without hiring a lawyer. The other time, there's statute of limitations, there's other times, but the other time is if you're talking to the insurance company and they say, sign this release, we'll give you $1,000, that means you're never getting a dime more in your life for that case. So the other way time is too late to hire a lawyer is if you've already settled your case. You may not realize it. You may think, I was just dealing with this nice claims adjuster. She was so nice on the phone. She was secretly sticking it to you.
So that does bring up a bit of a tangent question. So let's say because you said once you sign that release, saying that and the release is basically, we're done, hands off, this is all you're going to get. You're releasing this case from what? From any further litigation?
You're right. You're releasing them from their legal obligation to pay you in any way.
Okay. So my follow-up question to that would be, let's just say in a car accident case, you sign a release. Is there anything related to that at all that you could pursue, or is it all-encompassing?
99% of the time it's all encompassing.
Okay, so it's that important.
It's that important. They'll tell if it says they'll do it. If they have you sign a legal document to get a check, that's a release. You're releasing your claim. You don't do that. Don't do that until you've talked to a lawyer. They can give you a check, but don't sign the release, and don't sign a check if in the memo it says full release of all claims.
So will they actually put that on the check memo?
They will try to trick people like that because that's called in the law. It's called accord and satisfaction. There's some areas of powerful law. Now, was that a knowing release? Maybe not. Can you challenge it? Yeah. We had a case where this nice mom got a couple checks, one $200, 200 under $500, 2 checks. They sent her a release. She did not sign the release. We made a claim. They said, nope, you settled the case. No, we didn't. We filed a lawsuit. They said, you settled the claim. No, we didn't. And we fought this through taking video depositions for trial, like I said they did, and they turned around and gave us the policy limits of $100,000.
What was the initial offer on that?
It was zero. They said, we already gave you a $250 check and like $175. They say, we already paid you. I'm like, no, you didn't. I said, where's the signed release? She never signed it. Yeah, no, because we've been telling you that. Is no one listening to me? But they weren't. So
a couple $100 into $250,000.
Yeah. Oh, we do that. I have these articles I do from $0 to $100,000 or from $0 to $250,000. You've seen them because you do our stuff. I do them all the time because we get these letters where there's a $1,000 offer, $5,000 offer, and then we wait about a year later when we get that $100,000 or that $200,000 or whatever it is. I'm very proud of that work. That's real value added for someone who would have been screwed over by by a insurance company that does not care about them. Is only interested in that bottom line. But this is this person's life, and it's life changing. It's
Sure.
life changing, that amount of money.
Well, and two, to get more broad, when you're talking about a whole hundreds and hundreds of people that are geared and trained to just go after this one person, like you, again, not to go back to that statement of leveling the playing field, like they don't have anybody representing
No,
them.
they're getting all these calls and and you have to do this, and you need to sign here and do this.
Legal
do this,
talk,
do
scary
this,
threats.
Do this, you're not going to get anything. Oh, you need this money. How are you going to pay that? Oh, that mortgage payment you got to do next week. Well, you're going to lose your house. How about if you take this $1,000 from here and here, DocuSign this? The other thing is when we sign stuff now, click I agree and then click here. Yes, you can sign something on your phone. You think you're just getting a $1,000 check and you're signing away a $100,000 claim. You don't know.
Wow.
Isn't that crazy? I mean,
That
we
is crazy.
sign stuff on our phones all the time. Very
Well,
easy.
and
I do it.
sometimes it's beneficial, but it can also be used against people
don't know.
the same way.
You don't know. You got to be vigilant about that.